and I will be the facilitator for today's webinar. I sincerely thank you all for joining on time. While I continue the announcements, please, you can introduce yourselves in the comment box section. We also request that you follow Privacy Hub Africa and TechForGood Initiative. The TechForGood is spelled together. Capital letter T, capital letter F, and capital letter G on LinkedIn and YouTube. And also kindly engage with our content. To reiterate the notice that Zoom already provided, which all participants on this call have consented to, kindly note that all these sessions will be recorded and stored as per PHA's retention practices. Hence, your display name, voices, images, and any comment you make will be part of this recording. Today's topics will revolve around data protection impact assessment, data subject rights, the future of data privacy in Africa, and the evaluation of Africa's privacy landscape in the context of emerging technologies. And lastly, we will also deal with regulatory enforcement and compliance. So I will advise you to stay tuned up for this power-packed webinar. Please note that there will be room for questions and answers at the end of each session. If you have any questions, kindly indicate them in the chat so that we will not conflate the comments and the questions. I will kindly request that you put question, the word question in capital letters. Thank you. And as for our esteemed speakers, please kindly note that you have 20 to 30 and 25 to 30 minutes for your presentations. So without further ado, the first class will be taken by Dr. Nwankwo. Dr. Nwankwo, please, to our esteemed speakers, kindly pardon me for any incorrect pronunciation of your names. So Dr. Inhei Samuel Nwankwo is a postdoctoral researcher at the Institute for Legal Informatics, Leibniz University, Hanover, Germany, with over a decade of experience in data protection law, cybersecurity, and ICT law. He is the founder and executive director of the TechForGood Initiative, a civil society organization dedicated to leverage technology for sustainable development. As a former practicing lawyer in Nigeria, Dr. Nwankwo has a strong foundation in regulatory compliance and advocacy. He has contributed to over 10 EU-funded projects focusing on compliance, data protection, and ethics and emerging technologies. A prolific author, his peer-reviewed publications and widely respected blog provide invaluable insights for legal practitioners, researchers, and students, bridging gaps in ICT law and fostering knowledge sharing across Africa and beyond. Dr. Nwankwo also teaches European IT law part-time at Leibniz University's Faculty of Law, shaping future leaders in privacy and security. His work exemplifies a commitment to advancing data protection and ethical technology use on a global scale with a particular focus on Africa's digital transformation. So Dr. Uwanko, the floor is open to you. You may proceed.
Thank you so very much, Rachel, for that kind introduction. Thank you very much. Could I please be allowed to share my screen?
Yes, kindly do that.
I need the permission to do this. Oh.
Privacy Hub Africa, is it ready?
Okay, let me see if I could do this here. I will do this and try to share now.
Yeah.
Could you confirm you see my screen?
Yes, please.
Yes.
I can see it.
Perfect. Put it in the presentation mode, and thank you very much. And good evening, ladies and gentlemen. I'm happy to share a few thoughts with you on the topic of conducting a privacy impact assessment or data protection impact assessment, as the case may be. I'm having some issues here with my screen because something is blocking. Just a minute, I see if I can take this out. Okay.
Please, participants, kindly mute your mics. Thank you.
Thank you very much. So I'm going to look at how to conduct a data protection or privacy impact assessment. Sometimes people use those terms, I mean, interchangeably, but there is usually no harm because both actually address more or less the same objective. I'll try as much as possible to maintain the time. I'll quickly introduce the topic, look at some key points I think that will be relevant for practitioners, and we try to dive into how to really do a privacy impact assessment. So without wasting much of your time, the question that usually comes up is, what is an impact assessment? And the the International Association for Impact Assessment has tried to define this term. In their words, impact assessment is the process of identifying the future consequences of current or a proposed action. So the impact, properly so called, is the difference between what would happen with the action I'm about to take and what will happen without it. So if you literally translate this, let's assume you want to process personal data. What will happen if you process that data, and what will happen if you don't? So this is literally what impact assessment is. And over the years, it has been used in a number of environments or scenarios, the earliest being in environmental law, where environmental impact assessment was used to assess the impact of any project that may affect the environment. However, it has also been adopted in data privacy law. The earliest development one could think of relates to the initial adoption of the principles. The privacy principles as we know them today had no strict interpretation. Data controllers were left to interpret those principles based on the knowledge of their systems. So they had this free hand to interpret what is data minimization, what is legitimate interest, as the case may be. However, before the GDPR, the EU had what was called the Data Protection Directive. In that directive, they try to introduce another concept, the precautionary approach, right? Where certain data processing were seen as a little bit risky, and the data controllers were required to prior check the impact of this processing, or even consult the supervisory authorities. I think that was Article 17 then. They were required to notify that they want to do something in their thinking may be risky. So at that point, the idea of a formal impact assessment began to be explored by data controllers as a self-regulatory tool, right? However, the GDPR more or less formalized this approach using the risk-based approach, as we know, where a formal risk assessment is required, where certain data processing may result to high risk to the data subjects. So, and that is where we are today. The rest is history, because almost all nations today require a form of data protection or privacy impact assessment. So in essence, what does it mean? A data protection impact assessment simply means that a data controller is expected to adopt a conventional risk management framework and interpret those within the specific requirements of a particular law, for example, the GDPR, and then you will have a properly so-called a data protection impact assessment, because the concept of risk management, it is extra-legal. It originates from other fields, right? But it has been adopted. So over the years, we've seen a number of tools that are being developed specifically for privacy. There's the PRIAM. We also see the guidelines from ISO, the NIST, and the rest. So the tool more or less has matured over the years, right? And a number of entities have tried to merge this conventional risk framework plus the data protection requirements. A good example is this diagram here. It originated from the Spanish Data Protection Authority, right? Wherein, if you look at the right-hand side of this diagram, you would see the specific requirements of the GDPR, where you conduct a necessity and proportionality assessment. And if you look at the left-hand side of this diagram, you would see something that resembles ISO 3100 framework, right? So they try to combine this together to make sense of what is required of the law. They are not the only guys doing this. A number of others. This was part of the research I did for my PhD, where I also looked at ISO 3100 and try to adapt it to the requirements of Article 35 of the GDPR. It's somewhat a similar picture to what you saw earlier, but taking it from a different dimension. There are other frameworks. I don't need to bother you. However, you could also look at a data protection impact assessment from the broader enterprise risk management. An enterprise has so many risks to deal with. One relates to compliance, wherein an enterprise is expected to fulfill certain requirements from a particular law. In this case, if you are an entity that is processing personal data, then you are required by law to evaluate and mitigate risks that may accrue from that processing. That is where, in this case, DPR comes in. You could even go further to narrow down to something like a transfer impact assessment, where you are looking at a specific item, a specific process within your whole data processing environment, where you want to transfer data from one jurisdiction to the other. So if you look at this picture, it tells you that a data protection impact assessment is part and parcel of an enterprise risk management framework. This is important because as you do the impact assessment proper, you will need to refer back to certain policies from the enterprise. For example, how they categorize likelihood, the metrics they use for impact, for example, how they value risk. So it is very important here when you are dealing with this type of assessment. Having said those, I think there are few points that I think practitioners should know at this point. A data protection impact assessment is not a checklist, and it is not just a report, right? Over time, you see people flip a page document with pictures and they refer that as an impact assessment. No, it is not. It is not a checklist. It is a process. It is a process that is systematic, right? And you have to show this evidence. For example, that you consulted stakeholders while doing your impact assessment. So the documentary evidence is just the report, which could be detailed, or it could be in a summarized form. Sometimes there is no hard and fast rule as to the length of a DPR. It depends on the jurisdiction and the risk assessor, right?
Doc, please,
Yes.
can you kindly put your screen on presentation mode so that
I thought it was.
yeah.
I'm having a presentation mode here. Sorry.
Okay.
I'll cancel this and do it again. Confirm if it changed now.
No, it is still the same.
It is still the same.
Yes.
You can swap this, please, sir.
Okay. Let me see. Let me view it.
You may detach your second screen.
View and
now click on swap display.
Perfect. You've got it now, right?
Yes.
Yes.
My apologies. Sorry for
No
this.
problem.
Sorry for this. So one other key point to note is that in the current dispensation, as a practitioner, right, you cannot successfully or meaningfully complete a data protection impact assessment without having some knowledge of the technical system, right? Because the risks you are actually evaluating are logical in most instances. Days are gone when you look at a file cabinet and you look at the risk and say, just lock the door and that will be it. No, the risk you are looking at actually transcends beyond the four walls of that room. They are logical risks. So you must, to some extent, understand the technical aspect of what you are doing. Again, there is no universal template for a data protection impact assessment. However, whichever template you use, you should be able to show that you have covered the appropriate context. And context is key, right? The jurisdictional requirements must be reflected in whichever template you are using. And there should be, you should know the specifics of your information system. This matters a lot. As you will see, one of the examples I will refer to as we go along, right? So one other thing is that a DPR is collaborative in nature. We don't expect you to know everything about the system, no. Some of them are too technical that you may need to consult your technical officers, right? Some of them are, yeah, you can easily understand. So sometimes you may need to consult stakeholders like the data subject. So it is very important to know when to consult who. Now, I have to emphasize this. If you just complete a data protection impact assessment, perhaps send it to your superior to sign, and you put it in a box, and that is it. It doesn't make sense, because there must be a proper way of monitoring the controls you have suggested, right? And reviewing the DPR to know when it is obsolete, when you need to reassess it, and you must have some key performing indicators to inform you of the results. So without all this, you are more or less, I don't know, wasting your time, because you put it there and you'll be surprised that your colleagues are not actually implementing the recommendations. So you need to monitor and you need to review. And please, for the sake of whatever, don't do this. I see a number of templates. People just copy one page. You see this diagram, high, low, medium. It doesn't make sense. You are deceiving perhaps yourself as well as your organization. A DPR is a process. You need to know those processes, and you need to have a toolbox. Yes, when you publish your report, you could have a page that shows the metrics, right? But don't just rely on some of these templates online. A page, they ask you a question, you fill it, you click send, it turns out a page, and you are happy. You've done a DPR. No, it is not. It is important for you to understand the components of risk assessment and treatment, because what you are dealing with is extra legal. The law has provided certain requirements, but for you to do the practical DPR, you need to understand the traditional or the conventional risk management approaches. There are certain prerequisites you must know. Behind the scene, you must know you must have a risk criteria. You must be able to know how to define your metrics, right? And for the sake of time, I'm not going into any of these, but note that you can't just say that this risk is high or low or medium without having any metrics to measure. For example, you could say where a breach could affect 1,000 data subjects, then it is high in our metrics or in our criteria. We do ABC. This is how we know the likelihood of a risk happening, because we check our risk register to know over the past 1 year, for example, there has been incident, or 2 years. We could even check the industry, yeah, our colleagues in other industries or similar industry, what happened in their space over the past 1 year. So there must be a criteria for you to assess this thing. It's not, I mean, then if you adopt the ISO standard, for example, risk assessment is categorized into 3: the risk identification, risk analysis, and risk evaluation. You must know what each and every one of these process means, right? For example, risk identification is key. It is arguably the most important process of a risk assessment, because it gives you the opportunity to identify the uncertainty you are looking at. Because for there to be risk, there must be an element of uncertainty which will affect your objective, right? So you need to identify those, and this is the process. You have to identify the threats, the vulnerabilities, and the harm. Unfortunately, for want of time, I'm not able to define these terms, but they are common, right? However, as a risk assessor, you must have a toolbox. How do you identify those risks? Are you going to call experts? Do you have a register? Do you have a checklist? Are you going to paint a scenario and you analyze the scenario? How? Are you going to look at the past incidents and near misses? So there is a toolbox that you must be conversant with. Same applies to risk analysis. This stage gives you the opportunity to comprehend the characteristics of the risk, or of the risk you identified earlier. Let's say you identified the risk of a breach through perhaps a phishing attack, for example. You need to now understand how likely is this thing going to happen within our space, right? And if it happens, what are the consequences? What will be the magnitude, right? How volatile will our system be if a phishing attack occurs? You need to make sense of this, and there are techniques. You could use the quantitative analysis. You could use a qualitative analysis. You could, most times you use the mixed method. You use both to make sense of what you're doing. I mean, you could look at the statistics of what happened in the past, right? Again, the evaluation stage also perhaps gives you the opportunity to assess the significance of this risk. If this risk happens and this data is breached, will it be critical to us? For example, let's say it's health data. Then what is our risk appetite? Are we able to accept that level of risk? What will be the legal implications, right, to such a risk occurring? So you evaluate it. Each and every one of those risks you identified must be evaluated. And you ask yourself the question, Is this risk acceptable to us as an organization? Or do we need to do something to mitigate it? So this directly leads you to the risk treatment or the risk control measures that you will adopt in the future, right?
Doc, I hate to interrupt, but we have 5 minutes.
5 more minutes. Perfect. Perfect. So it directly leads you to the risk treatment. And for each risk you have identified, you must have a mitigating measure. You must have a control measure. If not, it doesn't make sense. If you don't control that risk, either you avoid it, reduce it, or perhaps you accept it, as the case may be. By the end of the exercise, you should have something like this, where you identify a particular risk, you analyze it, know the likelihood, know the impact, evaluate it, and control it. I mean, the table could be painted as you want, right? Having gotten this background knowledge, then when do you conduct a risk assessment? Is it optional in your case? Is it mandatory? You look at the law establishing the requirement. Are you required to do this ex ante before the risk occurs, or ex post after the risk has emerged? Right? The GDPR has this, as also other laws. Now, do you require to do a preliminary assessment before you do the full risk? So these are the things you need to understand as a practitioner. And then how do you conduct the risk proper? You need to look at a number of things. You have to analyze the law requiring you to do a risk assessment. In our case, in Nigeria, Section 28, I think in Kenya, 31, as the case may be. You have to check the guidelines from the supervisory authorities to know whether they require particular templates, right? You have to check if there are templates for reporting. This is very important. And in the EU, there are several examples. The EU, in France, they try to interpret theirs. They translated it into a software. You can download it. I've downloaded it. I've used it in several occasions. So there are also the paid ones, as the case may be. But whichever tool you are using, you have to get this background knowledge I earlier stated, because they don't reflect some of these things. Sometimes they ask you questions, you fill the questions, but those questions and answers are really not the full DPR process. Then you have to get this soft skill. Unfortunately, my time is running out, but it is important for you as a risk assessor here to navigate. You are the translator between what the law says. You have to understand the system architecture, and you have to understand any conventional risk management tool you are using. You are the navigator. If you don't understand this, the results may be a little bit I don't know, lacking in details and substance. By the end of the day, this is not relevant. I had wanted to perhaps give an example, but the time is off. Your documentation, you have to have a clear methodology and structure of how you document the processes. And for publication, sometimes it is not mandatory. You may need to keep it with you until you are asked to submit it, right? In some cases, you may be required to submit, but then you have to check whether there are certain information that ought not to be made public, like your trade secrets, as the case may be. No, I've said this, know when to consult the authorities, and if you complete a data protection impact assessment without recommending controls, I mean, without monitoring how your controls are being implemented, then it is more or less a love letter. It has no effect because nobody's going to do it. So you must have actionable recommendations. For example, we have to update this policy. It is the responsibility of the GRC. We do it in 3 months, 1 year, blah, blah, blah. You monitor it and it will make sense then. And for some of you who may want to do further research, I have listed 3 or 4 materials here. The open university risk management course is free and it's very good. I've looked at it. If you also want the French Data Protection Authority, they have a PR toolkit is also very rich. You could look at it. If you want to see an example of a DPR, go to the Ministry of Justice, the Dutch Ministry of Justice. There was a PR they did for Microsoft 365. The result of this PR changed everything in the EU, because it was an eye-opener to the authorities on how to do a PR properly, so-called. And it changed. After this PR, almost all the supervisory authorities initiated a PR against Microsoft, Google, and the case maybe. So I give them credit for such a wonderful work. Unfortunately, I have to stop here, and thank you very much for your time. I'm happy to answer some of your questions now.
Okay, thank you, Prof, for that enlightening session. I can see that there are no questions in the chat box. If anyone has a question, you can just do well to raise your hand. Please, can we have the slides removed? Thank you.
Right.
Oh, yeah. Okay, so somebody asked a question that who is responsible for DPI?
Well, the organization is responsible for DPI, but the law provides that the data protection officer must be consulted, at least in the EU, right? But it is the responsibility of the data controller.
Thank you. So that is
somebody's hand is raised.
okay.
Bibi
You
Tayo,
can
Bibi
unmute.
Tayo, if you can, you could unmute and ask your question.
Yes, Bibi Tayo, please.
All right, thank you so much, Doctor. Good afternoon, everyone. It's quite an insightful session. DPI is one of the areas in data protection that still sound abstract to a lot of people, especially people who are not related to compliance. So my questions are, in an instance where you are supposed to conduct a DPI for an organization, for instance, a fintech, and the law provides that you should conduct DPIA when you have deployed a new technology, or apart from that, you should conduct DPIA on the entire processing activities of the organization. So my question now is, where you're supposed to conduct for instance, a fintech, the fintech application, mobile application, they have ERP, their core, let's say, core operation software for operations. They have some other software, for instance, for onboarding. Now, you want to conduct BIA, is it to be conducted on each application separately, or can a particular DPIA cover for all those technologies? Thank you.
Yes, the answer is simply it could be for one, it could be for all, right? It depends on the purpose. If, for example, one thing, the essence of a DPI is actually to do this before the technology is deployed, assuming the technology has not been operational, because the result of this DPI will help you in designing your system, what they call privacy by design. So it is important, if you have the opportunity to do this before. Let's assume you have the idea. Let's assume you are designing your system, right? It is important for you to do this earlier because it gives you those control points. Again, you could do it for just one system. You could do it for all. It depends on the purpose. So for the purpose of complying with the law, I'm assuming that this fintech will have to do it for all the systems once personal data is processed across multiple systems. Thank you. Some other person also advocate, I couldn't read the name, Nosifo, if I get it right. Please unmute yourself, and if you want.
Please, for the remaining participants, if you have any question, you can drop it in the comment section because we are running out of time. Thank you.
And I see a number.
Yes, sorry, Doc. So because advocate is not speaking, let's quickly look at some of the questions in the comments.
Okay. Okay.
Yes.
I'm actually speaking.
Please, can you write down your question? Sorry for that.
I've written it already.
Okay. So I'll read the questions. The last question here says, share your thoughts on the distinction between privacy impact assessment and data protection impact assessment. Many colleagues confuse the two.
I see. I mean, it is all about nomenclature. I've said this. Both of them, the objective is more or less the same, right? But by virtue of the definition of privacy and data protection, one could argue that a data protection impact assessment is specific in the sense that it is focused on personal data per se, the informational aspect of privacy. Because privacy extends beyond the informational aspect. For example, the body privacy, right? If you are to do a privacy impact assessment, so-called, then we expect to see these other aspects, like the body harm dimension, the informational dimension, the spatial dimension, as the case may be. But in practice, those aspects are not emphasized. What is emphasized today, you will see a document titled Privacy Impact Assessment, but if you read it, it is focused on one, just the informational aspect. Another way to look at it is that a DPI has been mandated by law. In the EU, they use the nomenclature of data protection impact assessment. So you won't see privacy impact assessment in EU documents. Rather, more or less, you will see privacy impact, but more or less they are the same.
Thank you, Prof, for that wonderful answer. So because we have just 3 minutes for the questions, I will just take one more question. And the one I can see here is there any universal schedule for conducting a DPI, or each practitioner is at liberty to design his or her own?
There is no universally accepted template. But what happens in practice is that each data protection authority would have a sort of guideline per se. For example, in the EU, when I did my project, I could identify about 31 documents referring to data protection impact assessment. And now I'm sure you have double that number. So the first point of call is to look at your jurisdiction. Is there a template from your DPA or any regarded authority in that case? Then it is advisable to follow that template, right? But I have made this clear. The core knowledge spans beyond a mere template. You must have your toolbox of how you identify, analyze, and evaluate risk. The templates usually will be a questionnaire. They try to guide you answering certain questions, and that will be perhaps for the purposes of the authorities to evaluate what you are doing in summary. But you really need to do a data protection impact assessment, perhaps attached with the template or as part of the template. I don't know how usually they are.
And to round this up, please, it's not fixed that the DPI must be done just at the time of design. So it is good practice to conduct the DPI even during deployment, because someone
exactly
question in that.
Exactly. Also the law may mandate you to do a DPIA if there is a data breach. The EU GDPR also requires this. If there is a data breach, you may be mandated to assess the system again, apart from the one you did before.
Okay, thank you, Doc. A round of applause to Doc.
Okay, then I'll share the screen. I will share the slides. Sorry for the time; it's too short. This is knowledge you have to reduce it within 30 minutes. It's almost impossible to do this.
Yes.
Thank you.
We will be having some this type of sections and sessions in the coming years. So you will use that privilege or the opportunity to come back and tell us more about DPIs.
Thank you very much. Thank you.
Yes. So we will now transition into the second or the next class, where we will have Mr. Samuel Ungu talk to us about data subject rights. Mr. Samuel Ngo is a dynamic technology lawyer with expertise spanning data protection, artificial intelligence, financial technology, cryptocurrencies, telecommunications, and startups advisory. Recognized for his innovative contributions to the legal tech landscape, Samuel received the MODAG 2024 Spring Thought Leaders Award in the FinTech and Technology categories. He was also a two-time nominee for the Legal Ideas Award in the FinTech category 2023 and 2024, and he was named a Rising Star in Data Protection by PrivCon in 2023. Samuel is an active member of several prestigious local and international organizations, including Pan-African Youth Ambassadors for Internet Governance, Association of Privacy Lawyers in Africa, Stakeholders in Blockchain Association of Nigeria, FinTech Association of Nigeria, Technology Committee of the Nigerian Bar Association Section on Business Law, and Privacy Hub Africa. Samuel's passion for technology law and his leadership within these networks reflects his dedication to advancing privacy, fintech, and emerging technology standards in Nigeria and across Africa. Mr. Samuel, please, you may take the stage now. Thank you.
Thank you so much for Rachel for that wonderful intro. I want to seize this opportunity before I go to my presentation to thank Prof for that wonderful presentation on DPIA. So for some of us that practice data protection, we are very much aware that DPIA is more like a weapon fashioned against data protection lawyers, because it's such a technical, very difficult, and very long process to undertake. And being able to compress this within a space of 20 minutes, it can only show the sort of pedigree and expertise Prof has. So Prof, thank you so much. I welcome every one of us to my presentation today on data subjects or rights of data subjects. As you all know, this is a part of series of webinars organized by Privacy Hub Africa on understanding the fundamentals of data protection. These are the things we'll be discussing today. An introduction to data subjects rights, the nature of data subjects rights, types of data subjects rights, modalities, and conclusion. So, and these are our objectives. By the end of today, we should have learned, we are looking to learn from this webinar, the following things to know the various rights available to data subjects, to understand the natures of these rights and its modality, to understand how to comply with these rights. So I often start my presentation on data protection with this brief story that for centuries, we have been fighting for our rights, our fundamental human rights in the real world. And for some of us who are legal practitioners, you understand that the Magna Carta of 1215 was very crucial to the fight, for fundamental human rights all over the world, because that body of law made a provision that requires the body of an accused to be brought to the court before imprisonment. And that particular provision was very, very crucial to the fight, for fundamental human rights all over the world. Now, in this our present world, because of the proliferation of technology, because of the paradigm shift in digital economy, we now have a secondary world, the digital world. And currently, we are now fighting for this right in the digital world. So when you look at the essence of data protection, you will agree with me that the whole essence of data protection is to further this right, this fundamental right, but in the digital state, in the digital space. So when you look at data protection, you will also agree or understand that the soul, the heart of that space or that subject matter lies in the data subject's rights, because these are the rights that gives data subjects an opportunity to limit how an organization can lawfully process such data subjects' personal data, and thereby safeguarding the data subjects or the personal data from being used arbitrarily by institution or organization, as the case may be. So what is data subjects' rights? There are those rights available which the data protection law or maybe the constitution has granted to a data subject to enable such data subjects to control or to limit how an organization, an individual, both private and private institutions can process, or interact with such person's personal data. So we're looking at the nature of data protection rights. Because of the way this webinar is, because of the way we're asked to present this, we're looking at where we used GDPR as the basis, because generally all over the world, GDPR stands as the, the most or the fundamental legislation on data protection. So more like every other people try to draw inspiration from them. So you would see me making references and also, using some of the provisions of GDPR to explain these rights, and while also making a reference to Nigerian data protection regulations. So by the nature of data subjects' rights, or looking at the nature of data subjects' rights, in Europe, there is no controversy as to whether data subjects' rights is a fundamental human right. And this is so because Article 8 of the European Charter on Fundamental Human Rights specifically provides for rights to data protection as a fundamental human right, while Article 7 provides differently and specifically for right to privacy. But in Nigeria, we only have a section of the Constitution, Section 37, that provides for the rights of privacy of citizens. So for years, there has been different opinions. Stakeholders in the space have argued differently on whether rights, whether data protection rights are fundamental human rights. So some other people have projected that it is not, because data subjects' rights or data protection, strictly speaking, is not. Somebody is raising his hand up. Rachel, please.
Yes, please. Can you put your presentation?
Okay. Sir, please kindly expand the screen. Can you put it on presentation mode or the same way, Prof?
I think it's already on presentation mode. Please confirm.
Okay. It is.
Okay.
Mm-hmm.
And you can see it very well now.
Yes, we can see. I can see it. I'm not sure if
no, it's not in presentation mode yet.
It's not.
Yeah. Click the second button from current slide. Yes. So keep pressing your arrow key. The arrow key.
Right?
No.
I think
click on from current slide, the next button. From current
slide. Oh yeah.
No, on top in your controls to the left. Yes, click on that, please. Thank you.
Okay,
yes, you. So use your arrow key, back, front and back arrow. Yeah.
Yes. Thank you so much. Thank you very much. Yes. So as I was saying, in Nigeria, we've had stakeholders, thought leaders, differ on this particular issue, on the nature of data subjects' rights. And you can find a lot of articles where they have made their case why data subjects' rights should not be subsumed under the rights of privacy, and why rights of privacy should not be expanded to accommodate the right to data subjects. I wouldn't like to go much into the academics of this argument because the scope of our presentation today doesn't cover that. But whatever may be the case, the Court of Appeal in Digital Rights Lawyers Initiative and the National Identity Management Commission has held that the right to privacy as provided by Section 37 of the Nigerian Constitution is wide enough to accommodate data protection. So, as a matter of fact and law, as it is in Nigeria now, maybe pending when the Supreme Court overrules this decision, if at all it will, data subjects' rights are regarded as fundamental human rights in Nigeria. So, in terms of the nature of the rights, data subjects' rights are fundamental human rights. So, we are now looking at the types of data subjects' rights, and there are quite a lot of them. And I will be starting with the first, right to be informed. And this is the right a data subject has to be informed about how an organization, an institution, private or public, processes such data subject's personal data. This right, as a matter of fact, is automatic. It doesn't need a data subject to activate it before it applies. And this is because the law has entrusted this obligation on the data controller to ensure that prior to processing a data subject's personal information, that you must take steps to provide an information or to inform data subjects how you are going to process this personal information. So, and when you look at this right, so you will see that this right draws its inspiration from the principle of transparency, which requires, and to a large extent, fairness, which requires data controller to at all times be transparent with how the data controller processes the data subject's personal information. So I've listed some of the information that the law has requested at the barest minimum that you must provide to the data subject. And I dare to say that those information as contained by both the GDPR, the NDPA, and some other data protection laws all over the world is not limited in scope. You can decide to include as many information as possible. And I even say that aligns with the principle of transparency, which says that you must let the data subjects know how you process this information. So, but at the barest minimum, the law is going to look at the information they have itemized, whether you have covered that. And then if there are additions, that's fine, provided you are transparent in your processing activities and the information you give data subjects. So, with regards to right to be informed, there are channels you can inform this. You can provide this information to data subjects. All the law requires is that it must be prior to the collection of that information. And also, the information should be, provided, at the source or where you collect that information. So in that case, you see a lot of companies will go to their website, you see privacy notice or privacy policy, depending on the terminology used by data controllers, right? So because this right is actually manifested in privacy notice, privacy statement, or privacy policy. But that doesn't mean that it's only through online channel that you can provide this right. Where you are collecting information manually, you are expected to provide this information manually to the data subject in order for you to comply with this right. And I've provided the articles of GDPR and the NDPA that provides for this right. So we have right to access, and this is the right the data subject has to confirm, to approach data controller to confirm whether the data controller is processing the data subject's personal information. And when you look at this right, first of all, when a data subject sends a request to a data controller, it tries to ascertain whether the data controller is processing the such data subject's personal information. And then if the data controller is processing it, the data subject may go on to request for such information as the case may be. And then the data controller will respond or comply with that request. So when you look at this, you see, I can categorize this right into three. When a data subject sends for that confirmation, the data controller tries to verify maybe the identity of the data subject, and this is very important because if someone sends an information and you do not verify and you transfer another person's information, you have also violated the provision of the law. And to a large extent, you have occasional data breach, strictly speaking, because you have revealed information belonging to somebody, to another person. So that is why it is important for you to verify the identity of the data subject that is sending these rights. And the law has also said that in verifying the identity of the data subject, and the information you should request from the data subject for verification should be very proportionate and necessary to the verification you are to undertake. So when you have done this verification and then you go and check your record of processing activities and you see that you have this person's information, the law requires you to respond within a space of, GDPR says 1 month. Nigerian Data Protection Act says within a reasonable time, without stating what is the reasonability of such time. Anyway, we have case laws in Nigeria that, where the court has pronounced on what reasonable times mean. But it may just not be 1 month, maybe 6 months might even be reasonable. 1 year might even be reasonable, depending on the circumstances. But yes, this is what the data subject, the controller supposedly. And then the law requires that you should also send a copy of that personal data that the data subject has requested for. So when I look at the provision of the NDPA, it says the data subject sends a request, then you first of all confirm, and then if you are processing, you send an information more like an information that contains a replica of privacy notice or that contains all the information that is required in the privacy notice to the data subject. And then you will now send a copy of the information the data subject is asking for. And, to practicalize this, you can easily call your university and request for your transcript. That's an access request. You are asking for your information, right? You can call your bank to send you your bank statements. You are, to a large extent, complying or implementing this right, So there is also another thing I want to point out about the right to access, and that is that, for me, it's a gatekeeper, and I'm sure that the Court of Justice of the European Union has also pronounced on it, is a gatekeeper to all other rights. Because it is by the time when you have activated your right to access. In EU, they call it subject access request. In Nigeria, data subject access request. And then you are furnished with that information. Then you can decide to implement all other rights, right to erasure or deletion, restriction, objection, and all other rights. But that doesn't mean that when you are activating your right to access, that you must necessarily activate all other rights. That also does not mean that, when you will try to look at it from the practical point of view, there are also instances you may not send access requests and you just activate directly other rights. I hope it's clear on this. So another thing you must point out is that it's not a must that the data subject must be the one to send the access request. It suffices if the data subject authorizes a third party or a proxy to do this, such as a lawyer, an accountant, But the data controller must be careful to at least verify and ensure that the data subject has authorized this third party to make this request on his or her behalf. And there are so many ways you can do that. Maybe power of attorney and executed power of attorney can be a way to verify, or to ascertain that a data subject has authorized a third party to activate this right. So we have right to rectification. This is the right a data subject has to correct inaccurate personal data or to complete an incomplete personal data, right? And this right is tied to the principle of accuracy. By an extension, this right also applies automatically because the law, under the principle of accuracy, obligates data controller to ensure that at all material time, the personal information, the personal data they are processing is correct, is accurate. So, yeah, both the GDPR and the NDPA did not define what accuracy is, but if you look at the UK Data Protection Act, at least it provides what's inaccurate personal data is, and it says any information incorrect or misleading, any information that is misleading in fact, right, is regarded as inaccurate. Now, when you look at this right, it looks a bit simple, but it's very difficult in complying with. That is because what is accurate might be very subjective, right? I can tell you my age is that I was born in 2005. Jigget, and you have to comply with that. Also, there are instances where the information may not even necessarily be accurate, but the law also requires the data controller as a best practice to comply, with the data subject access request. Now, sometimes it may be difficult. Let's say there are instances where there is a record that is inaccurate, right? But let me explain. Let's say a certain medication was administered to a data subject, and it found out that it was realized that that medication that was administered to data subject probably may not just be the best registration, and a record of it has to be made to show that at this material time, this type of medication was administered on this data subject. In the real sense of it, that information is inaccurate, but keeping that record, may be very important for the purpose of justifying that record was made, right? So in that case now, it becomes difficult in drawing a thin line between an accurate information from inaccurate information. So it's important for data controllers and practitioners of data protection to pay attention to this. The court has said, and also the European Data Protection Guideline, their series of guidelines, they have advised that whenever a data subject activates rights to rectify, that it is important for the data controller to comply with the data subject's rectification request, as the case may be. So we have right to erasure, deletion.
Sorry for the interruption. I just wanted to remind you that you have 5 minutes.
Oh, wow.
Yes.
Okay, so we have right to erasure. And this is the right a data subject has to request the data controller to delete information that the data subject, that the data controller is lawfully or unlawfully processing, depending on the circumstances. And this right can be activated where the lawful basis for processing is consent and the data subject withdraws that consent. Where the data subject, where erasure is necessary for compliance with the law or national law, maybe for compliance with legal obligation, where data controller is processing the information unlawfully, where data subjects has activated their right to object and the controller doesn't have overriding interest. In any of these instances, the data controller will be required to delete the data subject's personal information. Also, there is a second leg of it where a data controller may decline to activate or to carry out this request. And that includes where the information is necessary for, promoting freedom of expression, right? Where the data controller's legitimate interest overrides data subject's right to object, where it's necessary to, carry out a tax in the public interest for archiving, scientific, historic research, and all of that. I also want to say that a data subject can actually decline rights to deletion where it borders, where the personal information requested relates to the data subject, data controller's trade secrets, right? So under the NDPA, you may not see some of these exceptions, but under Section 45 of the Constitution, there is a general exception to the implementation or exercising of fundamental human rights, which requires that these rights may be rejected or may be subdued for public interest, morality, safety, and all of that. So when you are advising people on, some of these rights under the Nigerian law, you must be very conscious that it is not absolute, and you must marry it side by side with the provisions of the Constitution. That's the exception to fundamental human rights. That is very, very important. So we have a case, Google Spain, which is more like a locus classicus on this principle, where an individual sends a request to Google to delist a publication concerning that individual, and then Google did not, and the person went to court, and the court actually held that Google was expected, or to delist that information. Right to restriction. I am rushing. So this is the right a data subject has to restrict data controller from processing the personal information. So this right doesn't require you to delete the personal information.
Participants, can you kindly mute your mics? Thank you.
So this right, when it is requested and activated, as the case may be, it only requires the data to be stored. It requires that the data controller should not use the data for any other thing except storing it. And this right can be activated where the accuracy of the data is in contest, or where the data subject is contesting the accuracy of the personal information, where the processing is unlawful and data subjects request restriction as opposed to deletion, where you don't want the data to be deleted, but you don't want the controller to keep processing it. You can activate this right. Where the controller no longer needs data for the purpose, but the data subject still requires it to activate. Maybe the data subject is anticipating litigation in future, and you don't want the data controller to delete this information. You can ask the data controller, you know what, just keep this information for me by the side. Or verification, verification of overriding grounds is pending where the data subject exercises the right to object. Just as I pointed out, the data subject can exercise right to object, and where the data controller's legitimate interest overrides it, it will decline. So there might be contention on that issue. So in that instance, the data controller is expected to restrict the processing. Now, implementing this right is very difficult, and based on guidelines issued by the European Data Protection Board and also Recital 67, it says you can actually separate this data from other data and just keep it in a separate system where it will be at rest. You can remove it from websites, and or just to implement or comply with this right. We have right to data portability. This is the right a data subject has to request the data controller to send his or her data to him, or to request the data controller to transfer that data to another data controller. Without going into the context, it can be activated only where the data is processed digitally or in through automated system, where the lawful basis is that of consent or contract. All of these things are provided under the data protection law, not the NDPA, but the NDPR. So another thing to point out about data portability is that a practical example of it is open banking. If you are a fintech lawyer, enabling different organizations to use a data subject information to offer different services. Maybe you are using OPay and you want to, your OPay is for your financial services or helping, but then you want OPay to share your data with maybe an insurance company that is sort of partnership with OPay, so that you can also activate a certain insurance. The OPay will transfer the data you've sent to them to that. That is also a way of implementing this right. Yeah.
Okay. So are you done?
So sorry. Right to object is the right a data subject has. So I've talked about right to object. You also have a right to object to direct marketing, and to implement this right, whenever you see an email, you always see an option, a button for you to object, to opt out of it. Is a way of complying with this right. But just as I said, is a right a data subject has to object to the processing of personal data in certain circumstances. The slide is ready, so you get through it, you will understand it more. So we have right to automated data. Please, how many minutes do I still have?
Your time is up, sir.
Oh, wow. Okay, so I'll round off now. We have right to automated decision making, and this is the right a data subject has not to be subjected to automated decision making, the use of AI and all of that. The law requires instances, that a data subject should not be subjected to this. Is automatic. It is an automatic right. It doesn't need a data subject to activate it before it can apply. And then an example of this is the use of AI, to carry out or to make decision, that will not enable human intervention. So there are processes the law has said when you are using this, you have to introduce human intervention, allow a data subject to contest the decision made by the AI and all of that. When you read this slide, you will understand. Then we have the right of broadcasting. When all of these rights are activated, a data controller is requested to take steps to, reach out to other third parties that the data controller has shown share the data subject's personal data with, and then ensure that these people also implement this right. In a nutshell, that's what right broadcasting means. We have right to lodge a complaint. You can petition the regulatory authority or go to court. Modalities, we've talked about this right, 1 month under the GDPR in Nigeria, reasonable time, and yeah, that is it. So with this, thank you. I'm available for questions. I'm so sorry for exceeding my time. Yeah.
Yes, no problem, sir. Thank you for this insight. We have a question in the comment box. It says, you persist to say that the right to erasure is not absolute, while you also say that the right to erasure, when implemented, it must also be implemented on the back end of the systems. In the case of financial institutions, is this right enforceable, given that anti-money laundering regulations may override this right?
So you have to be very careful. I said that data subjects' rights are not, especially rights to deletion, is not absolute. The law has stated instances where you can activate that. And I said in Nigeria, it's not absolute, right? Given the provision of Section 45 of the Constitution. So where you activate this right and it infringes any of those exceptions, the law, the data controller will decline. So you have said, if the Anti-Money Laundering Act has said you should not delete an information, of course, if a data subject requires that you should delete it, you will decline, because it is necessary for you to retain it to comply with legal obligation. It's so simple. So that is why I said it is not absolute. So there are instances where there may be overriding interest, maybe from the legal perspective, and also from the data controller's perspective, which I mentioned, trade secret, and also even where the data, if deleting the data will result in deleting a third party's data, and there is no way it can be redacted. And that is, these are overriding instances that will make a data controller to decline access to deletion.
Yes, thank you, sir, for your wonderful answer. And besides, consent itself and even the right to erasure in instances of law enforcement, it's not visible to even give the data subject such rights. This is seen in the law enforcement directive here in the EU. And it's important that we put context to some of these things as they are not all fixed and hard. So I wanted to also add that regarding the discrepancy of the boundaries between data protection and how privacy, and how data protection is subsumed under the right to privacy, right? As of the latter, the Nigerian jurisprudence is very similar to that of the Europe, not the European Union, right? Because under the Convention of European Convention of Human Rights, we can see that Article 8 enshrines the right to privacy, but there was no mention of data protection, but it's covered. You can invoke that article to protect your right to data protection. Then I also have a question. It's regarding the compliance with the transparency or information requirements for manual data collection, right? As it is not easily measured or established by data subjects. How can compliance with these requirements be achieved to safeguard the right to information? I ask this because it is a known practice for companies and even Nigerian courts, I don't know of other African courts, to maintain manual logs or archives without fully complying with this requirement.
Okay, thank you so much for that question on manual processing of personal information. What we don't even know is which one is easier to protect. Is it in the digital space or in the manual space? So looking at it practically, right, I would say it's even easier to contain manual processing than digital processing, because you may never restrict or be able to restrict where it can go with data that is already in the digital space. But for the one that is manually, it can be restricted. And there are measures, some organizations have shredders. In my office, once a document you are done using a document, we either you can burn it or you take it to the shredder where it will be, dissipated with. So people burn information, right? People shred information, right, when it is no longer needed. And these are some of the ways, it can be protected. Also, people have an archive where only access is granted on maybe on a need-to-know basis. So these are also instances on how to protect manual processing of it. I mean, this one can also even apply digitally, where a system that contains personal information, is locked and people are not allowed to gain entrance to that room. So, but these are some of the ways this information can be protected: through archiving, granting access to only limited number of persons, burning it, shredding it, and all of that. Yeah. I don't know whether this answers your question.
Yes, very well, sir. And somebody has a question. The person says, does the Ganishi proceedings practice in Nigeria fall within the right to access?
Okay, so I'll say it depends. It depends. So in garnishee proceeding, you already know you are asking some courts. You are going to court to order a bank, to pay you from the account of a debtor or somebody that is owing you. So it depends on, are you saying like, is it the request you make to the bank or the request you make to the individual owing? Maybe you need to clarify. Let me understand, right?
Yes,
Because
yes, sorry, please, for interrupting you. Please, the participants that asked the question, you can always reach out to Mr. Samuel Ongwe. In as much as we would love to learn from the answer, you can reach out to him on LinkedIn, same name, and I'm sure he'll.
Or you can give the person access to talk, so I can understand the perspective too. I mean, since it's an
Because we're
intelligent
running out of time, we have
Okay.
2 more sessions. Yes.
Okay, that's fine.
Yes, I sincerely apologize. Okay, moving on to the next session, we will have Mr. Ridwan speak on the future of privacy in Africa, while also evaluating the readiness of our legal landscape in regulating emerging technologies and the privacy-related issues they pose. Mr. Ridwan Oloyede is a seasoned expert in AI governance, data protection, and technology policy, with a strong focus on Africa and contributions to global privacy policy development. He is the director at the Center for Law and Innovation, CLI, and the co-founder of Tech Hive Advisory Africa, where he leads teams specializing in AI governance and regulatory intelligence, with extensive experience advising organizations across Africa, Europe, and the Middle East. Ridwan has guided companies on matters of data protection, digital ethics, and technology regulations. He is a trusted policy advisor and researcher with a rich portfolio of publications, including book chapters, reports, articles, and guides. Ridwan holds a master's in law and technology from Tilburg University in the Netherlands, and is recognized as a Fellow of Information Privacy, FIP, by the International Association of Privacy Professionals, IAPP. He is designated as an expert with the Council of Europe's Data Protection Unit and the OECD's Data Free Flow with Trust initiative. In reflecting his global standing in privacy and data governance. Through his leadership and expertise, Ridwan continues to shape policy frameworks and ethical practices in the rapidly evolving digital landscape. Please help me welcome to the stage Mr. Ridwan. The floor is yours. Thank you.
Right. Thank you, Rachel, for the long introduction. Hi, everyone. My name is Ridwan. Like you rightly said, I am a co-founder at Tech Advisory, and also I sit as a director at Center for Law and Innovation in Kigali, Rwanda. And today we'll be looking at future of data protection in Africa, looking at the trends, prediction, and preparing for emerging technologies. For me, I mean, what I'd like to start from is essentially, this feels more like something that needs taking some sort of historical perspective, but also why doing that, staying in the present. Part of the work that I've done in the last few years has somewhat focused more on being able to map trends, identify trends, spot trends, map trends, and create a story out of it. Because one thing, as far as Africa is concerned, is, I mean, now we've got like incredible number of people putting our content, telling story from different perspective of different countries. 4, 5, 10 years ago, that didn't exist. So now we have more information about data protection in Africa than we've had in the last few years. So, which is an incredible achievement if you think about it. So, I mean, my first rodeo with looking at trends was, I think it was first in 2019. And I tried to what we tried to do, my team then, was to create a report on activities of different data protection authorities at the continent. And that was quite tricky because the challenge then was a lot of authorities weren't putting out a lot of content about their work, so it had to track. And there's also like language barrier, and there isn't so much information. So we had to build that from scratch. And that became like a culture when we now put out like a roundup on data protection in Africa every year, and also have like an event basically looking at the trends that have come in the year, and then what are the predictions for the coming year. So just giving a bit of background about why this topic is so important to me, and whoever it is that's asked me to do it, thank you for that. A sizable part of my work is mapping trends and telling stories. All right, so getting things started. If you look at data protection in Africa, you can say it's taken so long before things kind of take root. Because if you look at, for example, the first country in the world to have a data protection law, or if you go back in the 80s when you talk about the Council of Europe came up with the first iteration of the Convention 108, or you talk about the OECD Transborder Data Flow, and quite a number of frameworks that have come before then. And you can also spiral into 1995, the EU decided, for example, to have its own directive, and that was in enforcement till 2016, 2018, thereabouts, before the GDPR came into force. So our first law in Africa, for example, was in 2001, when Cabo Verde came up with its data protection law. And that law was enforced for the longest time without actually creating an authority. And then right after, quite a number of countries also jumped on that bandwagon. We're talking about things in civil units. And in 2007, Burkina Faso took the lead to be the first data protection authority that was created in Africa. And that was even before Cape Verde. In 2002, for example, a country like Seychelles had a data protection law, which is completely distinct. And I know people like to say a lot that, many African data protection laws kind of take their influence from laws like GDPR. And sometimes when I hear these things, people also talk about data protection laws that even predates the GDPR. You can also say maybe some of them took some sort of an influence from the European directive and applied before the GDPR. But anyone who has had an opportunity to look at the 2002 version of the Seychelles law, we know it's completely distinct. It's something completely different from anything you've ever read. Of course, there are commonalities you always find in every data protection law. And that's to give a sense of how, aside the fact that Africa is not a country, so our data protection laws are not entirely the same in the true sense. Then bring it down a bit, quite a number of other countries came on board: Senegal, Morocco, Ghana, with its law in 2013. There was South Africa with the POP year, but it took a while before POP year 2 had full effect. Okay, my audio again. Okay, my audio. So in 2014, that was Malabo. Rachel, you want to say something?
No, sir. I just.
All right, thanks. In 2014, that was the Malabo Convention. And of course, it wasn't like in 2014 that they started drafting it. The drafting started pretty much earlier, but that was when it was put out. And as we speak currently, we have roughly about 40 laws in Africa. 40 countries in Africa with data protection laws. That's way more than half, because we're basically just looking at 15 other laws, 15 other countries without laws as we speak. And 34 of them have also either established or designated a public institution as a data protection authority. So what I mean by establish is those who establish data protection authorities solely with the mandate of data protection law. And when I mean designate, I mean those who had data protection responsibility to an existing regulator. So you can look at countries like South Africa, who had information regulator that had a different mandate, but now with the data protection mandate, or that has a dual mandate, let me put it that way. You can also look at countries like Zimbabwe. But you also have countries who they designate that to certain authority, but then they create like an office within that existing body to now stand alone. Like the law make reference to a different body, but then they create like a data protection body or office to be like some sort of standalone. So you can think of Rwanda, where the National Cybersecurity Authority is where you see, but then there's a data protection office that is primarily responsible for driving data protection within the office. You can also look at PDPO. There are quite a number of countries like Eswatini as well has the same model where there's a different body, then there's like the EDPA that is also like driving enforcement. So moving away with a bit of history, this is like a project I did in 2020, where basically I tried to like pull the timelines of the different data protection laws in Africa together, whether at the regional body or at the level of national level as well. So basically just creating a timeline for when these laws came into force and, just being able to use data to tell story, again, to be able to make sense of everything happening using data and also visualization. So this looked at, from 2001 to 2020 thereabouts, there wasn't a lot of laws. There were quite a number of laws because as at then we've already surpassed, we've gone midway. We've gone like, half of the countries already on the continent already had some form of laws. And we over 20 countries then already had some form of authority or also designated the authority. So what I'm putting out this visual is to help us see that timeline, see that progression that we've made as a continent. Pat Walsh, who's a very good friend, he's like a very interesting person who has like as interest in Africa. So he periodically updates this infographics, basically just showing the countries in Africa who have enacted a law or has a draft law and a bunch of stuff like that. So this was as of May 2019, where he posted these infographics. And you can see Kenya, for example, then had a draft law. There was, you could look at Tanzania, look at Zambia, look at Ethiopia, look at Egypt. It was all draft laws at that point in time. But then look at 2021, this January 2021, you can see how the transition, basically the color of Kenya changing from, I'm terrible with colors, the lighter shade of green, which is a draft law, to the darker shade now, because now there was a law as of 2020. So essentially, this is just to give us a sense of how far the continent has come in terms of the number of countries pushing for new laws, the number of countries that are also doing a few things around data protection in the space. So next to that infographics is something that is close to what we have right now, which is trying to show the number of countries with laws, the ones who have also created authorities along that, and also the ones without laws, but also even the ones with draft laws, as we know. Yeah. So this infographic is also a bit stale, and that's like the interesting thing about data protection in Africa. For someone who has followed the timeline very well, what you realize is if you keep your eyes off it for too long, there's always a new thing. So just when the year was wrapping up last year, Cameroon came up with this data protection law. So this infographics, for example, was talking about 39 countries. So now we have Cameroon, which now makes it 40. And look at last year, for example, and I mean, a lot of interesting things are happening. So if you look at South Sudan, look at Sierra Leone, look at Djibouti, Namibia. You also, I think I met folks from the Gambia last year who also said they're also currently working in a data protection law. So you have all of these countries who currently do not have a data protection law, but they are also currently working on one to build out one. So, I mean, predictions? Not yet. We're going to talk about predictions pretty much later. But what I can say for free is, if you're going to look at the next 5 years, we might be shooting north to, looking at maybe 50 countries thereabouts. Well, that's prediction. So essentially, this just gives us a sense of the kind of growth, the kind of progress we've made as a continent from 2001, when we had the first law, 2007, when we had the first data protection authority created, to now 2025, where we can now look at the state of things and you see quite a number of things that have been done. So moving on from that, so what are like the key trends that we've seen in the last 2 decades, for example? So the last 2 decades have been—
I wanted to remind you that you have just 5 minutes more.
Okay, was that in the communication to me? Or is this just like a new development?
No. I mean, I want to inform you that you have 5 minutes more.
Okay.
5 minutes to 10. Yes.
All right, interesting. Okay, so looking at the trends in the last 2 decades, quite a number of things have happened in the last 2 decades. And I said 2 decades because that's like really pivotal. Because of course, if you look at 2001, that's way more than the timeline I just spent. So some of the key things you've seen is we've had emergence of more laws from different countries. We've also seen amendments to existing laws, Seychelles, Botswana, Mauritius, all of these countries, Cape Verde at some point have amended their data protection law, and more countries are also in the pipeline to amend their laws, like Senegal. And some have also indicated interest in also amending their laws, like South Africa, for example. We also have a lot of data protection authorities that have been created within this timeline. Like I said, we currently have something that look like 34 of them. Egypt announced they are going to create one very soon to the 2020 law. And that's something we might see in Q1 this year, for example. Interestingly, we've also seen an interesting amount of sanctions and enforcement that have been issued by different data protection authorities. Angola, for example, takes the lead on this. You find the commercial bank quite an interesting amount of money. I'm going to pull up that data later. Then we've seen data protection authorities doing beyond just dropping, coming into force because the law asks them to be. They put out implementation guidelines, implementation frameworks. They've put out guidelines to also help clarify different parts of the data protection law to bring some sort of operationalization or functional meaning to those obligations. The courts have also played an interesting role, whether it's data subjects taking cases before the court or through strategic litigation by different advocacy bodies. We've seen quite a number of things, courts coming into the picture to kind of like define some of these things and sort of give like an extensive interpretation for some of the things that are ongoing in different countries, from Nigeria to Kenya, South Africa. There was a recent judgment of a court in South Africa, for example, that had to do with the enforcement notice issued by the regulator there to the department, to the government department. Another interesting dynamics that we've seen played out is also around cross-border data transfer rules. And this in itself can be like a whole topic. But from countries trying to give functional meaning to countries without clear international data transfer framework, to the ones who realized that, when the law was made, we created frameworks that it's almost commercially unviable, and now there's a need for us to amend our laws. We're also seeing an interesting move in terms of Morocco, Mauritius, who at some point have applied for the EU adequacy decision. And now Kenya is currently going through that particular process. And it looks like there's like some sort of positive light in the hand. We also have interesting conversations going on with alternative frameworks like the cross-border privacy rules, where you've seen Nigeria being a very big player in that alongside the US Department of Commerce. What will happen, we don't know yet. But there are quite a number of conversations we're doing as far as that is concerned. Then another thing also is collaboration and cooperation between DPAs. Quite a number of them every year you see being signed. AI regulation and governance is also like gaining ground, and there's a whole lot that data protection authorities are doing as far as AI regulation is concerned, from sanctions to enforcement to guidelines, to also taking on the global stage, contributing to global conversation. The data protection authorities in Africa are doing quite a lot. And maybe I'm having an opportunity to share an article that I co-authored recently, basically chronicling what data protection authorities in Africa are doing as it relates to AI regulation. There are also different international commitments, membership of data protection authorities. We also see an intersection of data protection with other domains like competition law, consumer protection, digital trade. And this is interesting because 2 years ago, the competition authorities in Africa decided to come together and they said, you know what, for this year, we're going to focus, in the coming years, we're going to focus on digital economy. And part of what we're going to do, we'll also be kind of working together with data protection authorities. And in countries like Nigeria, you've seen competition authorities and the data protection authority working together, especially with the digital lending problem. In South Africa, you've also seen investigation of things like abuse of dominant position, which also has like a strong data protection inflection. So another key thing that has come up with things like mandatory registration that you've seen across over 12 countries on the continent. You also have things like authorization, where you seek things authorization before processing, authorization for even things like data transfer. So That's just to scale it up. And now talking about the challenges, we know what our problems are, and I won't really go into them in details, just to give a sense of, regardless of what the challenge has been, regardless of what the journey has been, there have also been some challenges. Because sometimes I hear people make like comparison, African data protection authorities and data protection authorities in Europe. These authorities also have their challenges if you're patient enough to look at the annual report every year. You see the kind of things, the fact that they can't investigate things on time, or the fact that they're also screaming for resources and a bunch of stuff. Similar problems, to be honest, maybe not in the same depth, but problems are everywhere. There is no data protection authority that has everything it needs to fulfill its mandates. That I can say for sure. So, but moving on from there, I also tried to create like some sort of visual illustration to show what fine sanction has looked like from 2021 to 2023. That might seem abstract. Essentially just showing there have been like a growth, there have been like an increase in the amount of fines that we're seeing across the continent. So what is the prediction going to look like? Like I said, in the next 5 years, 10 years, I think is really going to be important for the landscape. And also because the conversation is changing. So we're going to see more laws, of course, amendment of more laws. Senegal, quite a number of countries are already talking about amending their laws. We're going to see creation of new authorities from the ones who have laws who are yet to create one, but new ones who are also creating laws, and then we have to have an authority to do that. Another big conversation you're going to see will be the intersection of data protection and emerging technologies. We're already seeing that with AI, but it's not just AI, attention-seeking child. We're going to see more technologies from, think about any emerging technology, put it wrap to wrap, you're going to see, as long as there are people, you're going to see data protection wearing its head. Sanction and enforcement is going to keep increasing. We see the incredible work the ODPC has done in Kenya in the past year. And this is really going to increase. The courts will also play an active role. Another thing that is going to be a big conversation is going to be things around child online safety and the intersection with data protection. We also expect to see a lot of work around cross-border data transfer. International data transfer is really going to be important. A lot of things are happening at the EAC level, for example, with the data governance framework the sub-region is trying to create. They're also trying to create a data protection law that we apply across the region that will also facilitate way better mobility for data. But we're also speaking about African countries who are giving themselves adequacy decisions, and also non-African countries who are also recognizing some African countries for adequacy decision, like we've seen with Serbia, Russia, Bahrain, who are sort of recognizing some African countries. Digital trade and competition is going to be very big. I'm betting on that. Competition framework in Africa is maturing. It's still pretty much, you can say, infancy, but it's maturing. I'm going to see a lot of that. Harmonization has been like a cliche word for the last decade. That you might see some work around, like what you see in the EAC. If we can achieve that scale at the African Union level, that would be, it will be interesting to see, but a lot of regional efforts as well. So, emerging technology, what should we brace up for? In thinking about what to brace up for, winter is coming, whatever is coming, the storm is coming, is we can run away from it. As far back as COVID here, for example, you can see the Mauritius Data Protection Authority put out guidelines. The authority in Morocco, as far back as 2019, for example, placed a moratorium on the use of facial recognition technology. So a lot is actually happening. Another thing that I think is going to happen, and I think because one problem we run from is people say, that we need AI-specific regulation or emerging technology-specific regulation. And there's like some sort of problem with that, because when you make technology a focus of regulation, you're going to have a problem, because you're basically going to keep chasing the regulation in itself. So one thing that I think might work is leveraging existing laws, existing regulators, to then go around the harm, the risk, and also the intersection. So that's something we're really going to see. But generally, everything else here would be more like a recommendation of what I think will be really important in how the continent shape and decide to approach emerging technology. So whether you go for principle-based models over rule-based, you need to choose. Rule-based are also very important because they offer some sort of clarity, but it could also be restrictive, not allowing flexibility. We have to see the intersection between data protection and other domain regulators, bringing them together under a clearinghouse model to work together. One is exposed violation, because we also need to know if the intervention is working the way it's designed, if it's solving the problem it's designed to solve. Quite a number of other innovative governance models that I think are going to be very pivotal moving forward. And I think I'm really going to shut up at this point.
Yes,
Yeah, thanks.
thank you.
Thanks for the time.
Thank you, sir, for wrapping up everything within the few minutes that you had. And sorry to our participants, please, if you have any questions, you can just reach out to the speakers. We're really sorry for not taking your questions. And there is an instruction in the comment box. It says that if you need a certificate of completion for the masterclass, you can just fill out the form there. So we will move on to the next speaker. In our last session, we will have Mr. Allen to talk at length regarding regulatory compliance and enforcement. Mr. Allen Maneji is the Data Protection Compliance Officer at the Postal and Telecommunications Regulatory Authority of Zimbabwe, Port West, playing a key role in implementing Zimbabwe's Cyber and Data Protection Act. He co-developed Zimbabwe's first Data Protection Officer certification course and leads modules on compliance and regulatory frameworks. A seasoned legal practitioner, Komborari, that's Mr. Allen, has represented Zimbabwe at international conferences addressing data protection, privacy, and digital rights. He is a founding member of Zimbabwe's Privacy Practitioners Association and actively conducts workshops and stakeholder engagement to promote compliance and awareness of data protection laws. Mr. Allen holds an LLB and LLM in international law from the University of Zimbabwe with a focus on internet privacy, digital rights, and AI. He is committed to advancing data protection in Zimbabwe through innovative policies and robust privacy frameworks. Please help me welcome on stage Mr. Allen. Thank you.
Thank you very much, Rachel, for the welcome. And thank you to the Privacy Hub for having me to come and do this presentation. And looking at the time, I know that I have about 18 minutes to make the presentation. When I prepared the presentation, I had prepared it in such a point form that it only guides me to explain the points I want to explain. So it's not as detailed, it's only 8 slides, and I'll try as much as possible to share what I can within the 8 minutes. And I'm hoping that you may be able to learn 1 or 2 things from the presentation. And I also hope that I'll be able to learn 1 or 2 things from you through interacting as we do a question and answer at the end of the presentation. So my topic was regulatory enforcement and compliance, navigating the evolving data privacy landscape in Africa. So I'll get right to it. So the presentation, I'll just mute my camera, and then I'll just go ahead and you'll be hearing my voice. I hope that's okay with you.
Yes, it's very fine.
Okay, so for the topic, as you might have realized, especially from the previous presentation by Mr. Ridan, if I'm pronouncing the name correct, if I'm not, my apologies. You have seen from his presentation where he gave a slide that I liked, where he talked about the evolution of data protection within the African context, and where we see that we have always had some data privacy regulation somewhere. In every country, there's always been a statute that has always been providing data protection laws. For example, you talk about the issues of confidentiality amongst information, talk about statute that would require that security be placed upon where you keep your information. But it's only now that we are getting to a point where we are putting this law into one piece of legislation, especially following the developments around the world, like with the GDPR. But if you look, almost all of the constitutions in Africa, almost all of the constitutions around the world, following the 1948 Declaration of Human Rights, talk about the right to privacy. And although it doesn't explicitly state about this right to privacy, but it talks about how everyone has got the right to privacy, but it doesn't explicitly state about information privacy or data protection. But it's only that data protection doesn't focus on the whole right to privacy, but only insofar as personal information is concerned. And you see how there's been a growth of data protection authorities in the region. We also have a network, what we call the NATPA, which is the Network of African Data Protection Authorities. We also have what we call the Global Privacy Assembly, which is a body from all over the world that governs data protection in the country. So you see how there is so much growth on data privacy, not only in Africa but around the world. And for the presentation, I'm just going to mainly focus on the challenges and the opportunities that are available, or what is it, or how do authorities around the world regulate data protection, and also try and provide what I think are the best strategies for effective compliance with data protection. I'm mainly speaking from my background, who works for the regulator in Zimbabwe. So I want labor us with this slide, because as we as we might have noticed in the previous presentation, I'm sure when I was following the previous speaker, they did, even the one that talked about the rights before, they tried to talk about why the privacy matters. So because of time, I'm going to skip this slide. So again, like it seems like I've never had a chance to meet the speakers here. I just got to know the first time, but it seems like me and the previous speaker, we had some telepathy that we had. But we just, the landscape of that position, we have seen that when the GDPR was formed in 2012 or 2014, we had the African heads of state meet in Malabo, and they come up with what we call the Malabo Convention, which is a regional framework on that portion that covers all the whole of Africa. And I also understand that the East African countries have got a data governance policy framework. I saw this when I was doing my research. I did not get the chance to go deep into it, but you also know that where I come from in SADC, we've got what you call the SADC model law that provides for data protection as well. But if you read the SADC model law and if you read the Malabo Convention, you see that they are very similar in not verbatimly similar, but you can pick that those who are responsible for writing at the African Union level, they might have had great influences, or they might have led on the same documents, which I also believe that it heavily borrows from the GDPR. So if you read these three instruments, the East African Data Governance Framework, unfortunately, I did not find anything on the West African countries, or neither did I find anything on the North African countries. But I would be happy if someone in the chat box can just drop something that you think I can also read around, and I also expand my knowledge. But then I just speak about 4 countries, but these are not the only countries in Africa that has got a data protection law. We know that, for example, here in Zimbabwe, we've got what we call the Cyber and Data Protection Act, which came into force in 2021. And I know the Kenya has got a law, the POPI in South Africa, the Nigerian Act. There are many laws. The Ghanaian one, I've read the act on Ghana. I know about Botswana. So as you can see that we started from the journey is still evolving. If you know more, for example, in Botswana, they had a data protection law that came into force some few years back, and only last year or early this year they had to reintroduce the law, and they have a new law altogether. And it seems like when you read around the white papers, those who were responsible in pushing for that law, they felt that the law that they had before was not as adequate as they have now. If you read the new Botswanan law, you see that they have tried to really align with the global standard like the GDPR, and they've also tried to align with the Malabo Convention. So you see that in Africa, we've seen that the landscape in the protection is evolving, which there are now more laws that we have. We now have more privacy authorities around, although you will then realize that some of the authorities are placed under a certain regulator. Not all of them are standalone. For example, in Zimbabwe, we are under the Postal and Telecommunications Regulatory Authority of Zimbabwe, which is POTRAS, which is mainly responsible for telecommunications regulator. And now we part of what we call Data Protection Authority, and we're a department in the authority. And you find that it's only there are other countries like South Africa. I know that the regulator, for example, is a standalone, but they also have a dual mandate because they're also the information regulator as well. So you see that we are moving towards like what the previous speaker said, we are moving towards an area where we will have more and more laws in data protection, which will be more refined, which will take into account the evolving digital landscape that we have on the continent. So how do regulators enforce data protection? What are the enforcement mechanism? What should we expect from different regulators? So what I did with my presentation, although I on my paper certain provisions from different laws, but what I tried to do was just to pick up the enforcement mechanism that cuts across all the different pieces of legislation. So it's not like I took this from a particular piece of act, but I took it across different legislations. But the first enforcement mechanism that you must just first all you want to understand is that the authorities, you've got what we call the powers of the authorities. If you read the constitutive documents, most of these documents, they have a particular section where they have what do they call the functions of the authority or the powers of the authority, which describes how does the authority function, what does it do. For example, if you read section 6 of the Zimbabwean Act, we've got what it defines what does the Data Protection Authority of Zimbabwe do, what do they do, and amongst the other what we have is that we can issue even what you call these implementation guidelines of the law to say that this is how you implement the CDPA law. And like any other law across the continent, each and every regulation in Africa, all of them provides for penalties for non-compliance. And there are administrative fines those are the they are administrative fines. Those are the penalties that I'm referring to say that they will say that if for this violation, they are going to order you to pay this amount of money as a matter of you not complying with the law. I know that the South African regulator, they did fine Meta for not having an adequate privacy status for South Africans in South Africa. And I know that they have appealed and it's something that is currently under the South African court. They did also place an administrative fine on the judicial system, or on the Minister of Justice, I think, for also not for non-adherence or for non-compliance with the law. So this is something that we have across the African country, even in Zimbabwe, even in Nigeria. You read their acts, they've got penalties for non-compliance. And also the authorities can also issue compliance orders, with an order that they will say that carry out this act by this time. For example, when a data subject comes to report and say, for example, they wanted to access the information through a data subject access request, they can tell you that we did approach this type of an organization. We did ask them to do this, but they didn't done so. So the authorities can always issue a compliance order that we are ordering you to comply with this. So in that, they might not want to fine for the violation, but what they want to do is to seek compliance, and they can do through that the powers that are bestowed upon them. Authorities can also carry out audits and investigations. So whenever you obviously receive a complaint, you need to carry out an investigation. It's in form of an audit where you know the current audit that we only have in our companies, where at the end of the financial year or it's a particular interval, you can have an external auditor come into place to check if you are complying with the relevant company policies that you have set for yourselves. So that's the same thing with DPAs. They can always go and carry out an audit at a particular data controller for non-compliance, even if they are compliant, but they can just do, for instance, in our Act in Zimbabwe, we do provide for ad hoc inspections that you can just call you for an ad hoc inspection, you can call you for an off-site inspection at our offices, or we can come for an on-site inspection. So it's a power that we have for enforcing as enforcement mechanism. Because if you carry out the audit and the investigation, you should then be able to call upon them to do a particular act. And then after that, you can also issue what we call a data processing ban, whereby you can say to this organization, you may not process any personal information because possibly you find them or possibly you've issued them with a compliance order that they haven't complied with. Obviously, the next thing you can tell them that it's an extreme enforcement mechanism whereby you tell them that you are not processing personal information. And for many businesses, if you cannot process personal information, you cannot operate as a business. How, for example, will you be able to have employees as part of your organization. Then you've got what is named the name and shaming. Although this is not a very popular one, but it can be done. It can be done diplomatically. You can easily issue a statement say that these are the organizations in this country or in this province that have complied with this part of the law, which then points out to some people to say that they haven't if they haven't complied with your law, if you haven't complied with your law, then you are obviously going to face this sort of the music. You can approach the court. Our law, especially in Zimbabwe, allows us to approach the administrative courts, because you know that the DPAs have got what you call the quasi judicial functions, because they are authorities that can issue decisions, that can enforce a part of the law. They've got what you call a quasi judicial function, but obviously those decisions are subject to the administrative courts, because the roles that the DPAs hold is an administrative function. So they always have to be submitted to an administrative body, like such as a court. So even the DPAs themselves, they can also approach the administrative court for them to issue out an interpretation of a part of the law that otherwise they might not want to issue on their own. It's something that is also very popular within the Zimbabwean legislation. And lastly, I say this, I know most laws, they don't have this, but they can also report a violation to the police. So we know that, for example, if you read the current Botswana law, you realize that there are criminal sanctions for non-compliance with data protection laws. So where there's a violation and where a criminal sanction applies, you can then approach the police to report the violation, because we know that every criminal case starts with the police arresting the person first and issuing a statement. But the criminal sanctions, their application differs from one organization to another. In Zimbabwe, the criminal sanction is placed on the accounting officer unless they can place strict liability on the DPO for not carrying out their roles. But if you're non-compliance of a data controller, you don't arrest the controller because it's an organization. Mostly you're going to go for the accounting officer, that organization. But some other countries place the different violations of different individuals. And we know that most of the laws now have what you call the cyber crimes, which are also meant to help and to support the enforcement of this piece of legislation. There are various challenges. There are so many challenges in regulatory compliance. I mean, there's a lot that you can point out, but I just picked up a few, about 5 of those, and then there are a lot that you can always talk about. And I think the first challenge is that there is a lack of harmonization between national laws. For example, I liked when the presenter who presented the rights was presenting, someone asked about what takes precedence between the anti-money laundering regulation and data protection regulation. So I find that there might be contradicting positions in the law, so that the anti-money laundering regulation provides for this, but the data protection regulation provides for that. So what you want to know, or what you want to understand, is that which law or which legislation should you follow first. For the lack of harmonization, you need to understand which one comes first, and for that to happen, it cannot be done by the DPAs, or neither can the controllers themselves be able to understand what to do. It's something that also goes back to the legislatures themselves to ask them to say which law should override which law. But at some point, even the DPA, the DP laws, they should also be able to provide for exceptions. To say, for example, if you read most of the laws, they've got what you call the exceptions to processing of information, what you call the legal obligation, whereby data may be processed even without the consent of the data subject, because there's a law that says that this process can take place. For example, in Zimbabwe, we say that whenever there's a law that is there in place, data protection laws will not override that piece of legislation. For instance, all banking transactions in Zimbabwe must be kept for up to 7 years, as per our anti-money laundering regulations. That's the same thing. So whenever we want to process banking information, the subject must be informed, as per their right, that this information will be kept in the bank up to 7 years, because the anti-money laundering regulation in the country requires that we keep them for 7 years. Even if the just subject exercises their right to erasure or to be deleted, they cannot be deleted, because there's a law that says whatever they've transacted, that law must be kept for up to 7 years. We also have limited awareness and capacity building. Most people, especially in my country, we have these laws that we have, that we now have a piece of legislation that is a good one, that has got a lot of information. But are the people who are supposed to be followed by this law, are they aware about this law, and even the data controllers themselves. You have people asking you, do you think this law is for us? They are not aware that it's a law that they ought to implement. And some of the companies, especially in countries, in most African countries where you've got a high informal sector, where most of the controllers are in informal sector, they are small to medium business enterprises. They don't have the capacity to be able to comply with this law. You know, compliance is not negotiable, and compliance is an expensive part of Hello guys, do you still hear me?
Yes, sir.
Yes, please.
Okay, sure.
Yes,
and then
please.
you know sorry. And you know that compliance
Yes,
is not
we can.
negotiated. So some of the small to medium enterprises may not have the capacity that they require for them to be able to comply with data protection laws. Then we also have the use of emerging technologies. Someone says to me, are they still emerging? Because things like AI, Internet of Things, and big data are already part of us. We already employ and enjoy these technologies. So maybe they're not so emerging anymore. But for the lack of a better term, I'll just say emerging technologies. Because how are you able to comply if you want to employ an AI system that did not originate in your country? For example, we in Zimbabwe don't have a lot of people that have come up with good developments around technologies themselves, but we still want to use these technologies for us to be able to benefit from them, but they make our lives easier. So how are you able to comply with data protection laws when you cannot when you don't have control over these technologies? For example, we want to understand when you're using AI for processing information for coming up decisions. We want to know how, where, if you load the data on the AI system, where is the data stored, all those things, and you don't want the data to go beyond the Zimbabwean borders. But is that possible for an organization that solely wants to rely on technology for improved efficiency? We all have almost all of the legislation that I read, they've got corporate data transfers and location requirements, where we say that no data shall move beyond the country's borders. Each data must be localized. We don't have any country that have got a localization law like India and China, but all of our access that you need to take data to a country with the adequate status. We know we want the adequate status to be part of the countries that we take our information. So obviously, it is a very difficult requirement to really comply with, because, for example, almost all organizations, they might want to use Outlook for emails. We also want to communicate with the drives using Gmail. So how feasible is this to say that you comply with the law with that doesn't want you to take information beyond your country's borders, when in your country you might not have that perspective that you want to use, such as your Outlook and other services that make our lives easier. So the issue of data cross-border restrictions also make it difficult to combat those. But some of the things that we want to enjoy, they don't originate in our own countries, and they require us taking the information beyond our country's borders. So it's a challenge that we need to re-navigate, or we need to have an harmonization as an African continent to say that how best can we harmonize in these areas so that it's easier for our organizations in our own countries to take information from one border to another. And obviously, there's resource constraints for all DPAs. So, if according to the NADPA, most of the DPAs that were formed, they haven't done very well, or they haven't kicked their job because they don't have the resources to do so. You know, for example, you need to get out awareness in all of those things, need resources, and without the adequate support from the government or from the treasury, you might not be able to carry out your responsibility as an organization. So the last slide before we go, these are the strategies for effective compliance. These are just a few ones that I just came up with. I hope they'll help. So obviously, the first thing that you need to do as an organization or as a data controller is that you need to carry out a regular audit on your data protection practice, or your processing activities at your organization. You need to do your gap analysis. You need to do your DPIA. All these are part of what you call a type of some form of an audit that you can perform. So you need to have an effective data protection department that is always carrying out audits to make sure that where are there any gaps? What is the state that we are in? Where do you want to go? It must be a regular activity that you must carry out. You also need to develop a robust policies in the organization. You need to have your legal policy, for instance. For example, the legal policy will give you to guide you to say that What are the laws that affect us as a controller in the industry that we operate in? If you're in the mining industry, what are the mining regulations? How do these complement or how do these contrast in the data protection laws that you want to follow, and how best we go about issuing compliance so that you also comply with the certain laws that you have and also comply with the DP laws that are in existence. But the policy should be a lot. You need to have the policy on consent, the policy on detention policies. You need to develop a lot of policies that will help you comply with the law. You need to develop a policy on data breach, including the data breach response plan, all those things. What happens? At what point do you know that there's been a data breach? What do? You also need to invest in training of your own staff. It's for you to be able to comply with data protection, your staff members need to understand what data protection is first. Because even if you have a DPO, most organizations, especially in Zimbabwe, they only have one DPO. So even a department, it's not easy. It will be important for the DPO to, even for big organizations like banks, to be able to oversee all the departments or to oversee each and every individual to say that are they enforcing or are they complying with the data protection laws that you have. So obviously, you need to train staff members now and again so that they understand data protection and they know what needs to do. You can also leverage on technologies use of compliance tools. We know have a lot of compliance tools that we have that can help us comply with data protection. And lastly, you need to engage regulators. Always have a colloquial meeting with the regulator, especially here in Zimbabwe. Our approach is that we all have stakeholder engagement meetings. For example, last year we came up with 5 implementing guidelines on data protection, like the guideline on consent, on minors, on appointment of DPOs. We've got 5 guidelines. So before we roll out the guidelines, we took all we said to all the DPOs for different organizations that those who are registered with us, can we go for a 4-day meeting to consult the regulator, the DPOs on the guidelines we published. So we gave them the guidelines in advance, they read them, and then we expect them to come and give us feedback. So you see that some DPOs might not just attend. I know some organizations, they might not want to send their people, but someone might not just attend because it's a meeting by the regulator. But you need to engage with the regulators, consult them, where you have an ambiguity, let them explain to you how they see things, so that at the end of the day, you don't do things that are in contrast to what they're expecting from you. I know, ladies and gentlemen, please forgive me. I know this was a rushed presentation. I've come to the end of the presentation, so I hope I can just take a few questions if there are any.
Yes, thank you for this rich presentation, sir. It was quite remarkable. So because we do not have enough time and we do not want to keep other participants who might have some commitment somewhere, we want to respect their time. Because of that, we cannot proceed with the question and answer section. Please, if you have any question, you can always reach out to the speakers. So we have come to the end of today's webinar. Please do not forget to follow and mention us on all our social media platforms. And thank you once again to our remarkable speakers, to PHA, Tech4Good Initiative, and all our participants for joining us. I will now pass the floor to Mr. Solomon, the Executive Director of PHA, for the closing remarks. Thank you.
Thank you, Rachel. Thank you very much. Wow. You would agree with me all that this masterclass has been nothing short of impactful. Personally, my expectations have been exceeded. I would first of all, on behalf of PHA team and the DPPM organizing committee, say a big thank you to our experts course instructors for their time and for sharing their expertise with us. I would mention their name because it's actually necessary. Dr. Mugambi Laibuta, Mr. Olumide Babalola, Mr. Benga Odubemi, Mr. Harry Boje, our very revered Amaka Ibeji, Winnie Ngige from Kenya, Dr. Iha Inwankwo, Mr. Samuel Ngu, Mr. Ridwan Oloyede, and Mr. Alan Menenji from Zimbabwe. these are thought leaders. They are leaders. They are our fathers in the industry, in the privacy industry in Africa. I respect each and every one of them a lot. And I'm very grateful that they actually honored our invitation for this masterclass. So, and I also want to thank our amazing facilitators, Advocate Dironsho Mohale from South Africa, Abigail Sami from Kenya, and the last lady that I spoke to you, Rachel. I don't know whether she's from Nigeria or Netherlands. Thank you very much. Thank you. And to our partners at TechForGood Initiative, thank you very much. Thank you. We are grateful. Please do well to follow us on LinkedIn and subscribe to our YouTube channel so as to keep abreast with our programs and events. If you would want to get a certificate of completion for this masterclass, you could just fill out the form that you can see from the chat session. And there's something I need to do. I want to use this medium as well to appreciate and to celebrate our advisors, the members of the PHA Advisory Board, Professor Sizwe Lindelo Snell from South Africa, Mr. Oludare is in Ireland, but I don't know, he's Nigerian anyway. Mrs. Amaka Ibeji and Dr. Mugambi Laibuta from Kenya and Dr. Patricia Boche. They have been our pillars and they've been so helpful and resourceful to PHA. So thank you very much for attending this masterclass. And I would also encourage you to share your key takeaways and insights on LinkedIn, tagging Privacy Hub Africa, and our partner TechForGood Initiative. So thank you very much. And if you have any question, like if you want to join PHA Volunteers Network on WhatsApp, you can reach out to a number we will drop on the chat session now, or you can just reply to our email. The emails have been sending to the participants asking to join the Volunteers Network. Thank you very much and have a wonderful day. Thank you.
Thank you, everyone.
Thank you very much.
Bye.
Bye-bye and have a good evening.
Thank you, everyone.
Thank you so much.
Thank you. Great insights. Thank you.
Thank you so much.
Bye.
Thank you.
Thank you.